Court refusing to block the release of Donald Trump's documents. What do you make of that?
Yeah, big news, Nicole. I hope you're willing to extend your marathon coverage another minute here with us. I was watching Rachel, your great panel. And this was one of those news days in Washington. I was really listening to how you guys broke down what the president said about Ukraine, about those tough questions he got, some of which seemed out of bounds, as well as the voting rights, the spending. And then we get this decision here. Overwhelming for the Supreme Court. It looks like about an 8-1. We talk a lot about things being divided, but this is the Supreme Court saying no to Donald Trump. You are not a king. You are not still president. And interestingly, even if you were still president, the Chief Justice wrote in this brief opinion, he went out of the way to say, even if you were still president, we would reject your attempt to hide this kind of evidence on a matter of this import. So bottom line translation, anything that Donald Trump wanted to block for whatever his reasons were related to January 6th investigation is cleared to go from the archives to the investigation, Nicole.
Ari, do you have an understanding of how quickly that happens? I mean, I know the documents have been identified. They've been vetted by this White House counsel, President Biden's White House counsel. Do you have any sense of how quickly they could be transmitted to the committee?
I would say I don't. The opinion itself does not speak to the timeline in any way. So that then becomes, as you know from your government service, one of those things between the archives and the Congress. I think the Congress's view, as you alluded to, is that they know what they want. They've identified it. It exists. They're ready for it. I mean, that's already been litigated. But whether the archives has a process or a way that they need a certain amount of time, I don't have that in front of me. I do think it's interesting to, again, emphasize that there are presidential questions that are close calls, difficult cases the Supreme Court hears. This opinion shows this court, on a really basis of most of the court, Republican and Democratic appointees, they didn't find this a close question. They think Donald Trump was wrong and the loser of this kind of claim.
It's amazing. Don't say anything too great until I have time to take off my microphone and run down to my office and listen to the rest of your program. Thank you for sharing your on-air real estate with me. Have a great show tonight, Ari.
And likewise, we've been watching. So thank you, Nicole, and thanks for the marathon coverage with everyone. And we're going to keep on the breaking news right here. You're watching MSNBC special coverage as it continues. A big Supreme Court case, a big loss for Donald Trump. I want to bring in Emily Bazelon, a staff writer on legal issues for the New York Times Magazine, who has jumped into a breaking news mode with us. Emily, I'll say that we're fortunate here. The decision is pretty clear and pretty short. Tell us how you read it, what it means.
Well, I mean, I think that this was a pretty weak legal claim, given that past presidential records are owned by the American public. That's the law we have, the post-Watergate law from the 1970s. And I think the Supreme Court made it clear that they did not agree with former President Trump's argument that the documents be kept secret. And I would expect them to be turned over fairly quickly because the Supreme Court is the end of the road.
Yeah, there's no other option here for the former president here. He had his reasons, as I mentioned, of why he wanted to block this, why he doesn't think that this would be, to put it in legal terms, exculpatory, that there might be something in here that he doesn't want out there. And I want you to stay with us. This is one of those breaking news days. I'm told Nick Ackerman is in place and is going to join our coverage, a former Watergate prosecutor, a counselor versed in these kind of issues. Nick, welcome. I'll let you get situated here. My follow-up question to Emily is something I was just discussing with Nicole Walsh. I want your take as well. This is kind of legal breaking news, so I don't know what you thought of this line, but I'm going to go to Emily and then Nick on this. They say, Emily, in the opinion here, which was written here, I want to say, Chief Justice writing it, the privilege claim here would not succeed even under the Nixon and Senate Select Committee tests. And they go on to say, even if Donald Trump were the incumbent, which is to say if he were still president, they agree with the lower courts that had said, Emily, his claims were so weak he would not be able to hold back this evidence. Your response or analysis of that?
Well, I think the Nixon history is important here because the reason we have this law from 1978 about the public owning presidential records was concern that Congress had about the level of secrecy that President Nixon was trying to maintain when he was in office related to the Watergate break-in and ensuing scandal. And the 1970s are really the moment post-Nixon where we get a lot of these access laws, this idea that sunlight is the best disinfectant, and we are going to let the public in on what people in government are doing and saying. And so I think what you see here is Trump trying to protect his past records, and the Supreme Court saying, you know what, even if you were still the president, you wouldn't be able to assert this privilege, and you certainly can't do so now that you're out of office.
Same question to you as we talk Watergate, our former Watergate prosecutor, Nick.
Well, I think what they're saying here is that executive privilege just does not apply. You can't take executive privilege other than what the Supreme Court said in 1974 in U.S. versus Nixon, unless it relates to diplomatic affairs, national security, military affairs. It certainly doesn't cover an insurrection and an effort to overthrow the government, and the first branch of government being the Congress. So what they're saying is, even if Trump were still president now, they would still order this to be turned over because executive privilege does not apply under any interpretation of that privilege. That's what's going on here. And what's amazing is they came down with this without any oral argument, without further briefing. I mean, the District of Columbia Circuit Court decision was very detailed. I mean, Trump came back with zero facts in terms of justifying executive privilege here. And I think the Supreme Court, as I had predicted, really wouldn't take this case because there was nothing more to say. Everything had been covered by the District Court and the District of Columbia. And I think from the standpoint of the January 6th committee, this is a resounding victory. This is going to give them information that goes to Donald Trump's intent. And the question is, the big question is he guilty? Should he be indicted for obstructing Congress? And there's going to be evidence in here. For example, he took a number of different takes on that message that he gave to his supporters to leave the Capitol. There are at least 2 other takes that were done on that. And for whatever reason, the people in the White House didn't think those were good enough. So the question is, what did he say, and why did they not, go ahead with what he said earlier? My guess is Nick, none of that's going to help him.
And Nick, I'm curious what you think. Again, this is breaking news. We just got this coming out of the president's press conference, the Supreme Court rejecting Donald Trump's request to hide this January 6th evidence on an 8-1 decision. And Nick, that means that most members of the court rejected Trump. That includes most of the Republican-appointed members. It includes several justices that he himself appointed. What does that say to you, Nick, at a time where the president was just talking about how polarized we are and how Republicans in the Senate, they won't do anything with him. He says it's worse obstruction than the Obama era. The public, well aware of that polarization, a lot of cynicism about all kinds of institutions, including the court. What does it say to you that this was an 8-1 ruling? And is there anything good in there about the rule of law?
Yeah, of course there is. I mean, this is exactly what happened to Watergate. This is deja vu all over again, to quote Yogi Berra. Everybody before the tapes decision was saying, oh, my God, Nixon's got his own appointees in there. There's no way we're going to get the tapes. It's going to go down partisan lines. It didn't. That was an 8-0 decision. One justice wound up recusing himself. Here you got 8 votes again. But it really says a lot about the rule of law and the way our system of government works, why we have an independent judiciary where Supreme Court justices are appointed for life, can't be removed for any reason. They can, Trump, in his mind, I'm sure believed that the appointees that he put on there are beholden to him, that they owe him something. In his mind, that's what he thought. But that is not the way our system works. And this proved that, again, the same thing that happened in Watergate, the same thing that the Supreme Court upheld the rule of law with respect to executive privilege.
Emily?
This is a very conservative, ardently conservative court, and it is going to change the law and move it to the right in important, dramatic ways this year and in the years to come. However, as Nick points out, they're not loyal to the person who appointed them. They are a separate branch. And so when Trump comes in with very weak legal arguments, the justices are going to take the opportunity to prove their independence. And I think that's what you're seeing here. You're seeing them assert themselves as a separate branch of government.